On this episode of Off the Clock, Rebecca and Sarah continue their discussion on what changes companies could see with the new administration in Washington.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
So a theme that we're going to talk about more, but I'll start it now. The traditional labels, Democrat with a capital D, Republican with a capital R, are no longer as indicative of the relationship with labor and how supportive we're going to be towards labor, right, and traditional unions. So things are different now and might be a little unpredictable. So during the campaign, Trump worked very hard to earn support of union leadership as well as rank and file union members. And as some call it a payback, use whatever phrase you will, but he did surprise some Republicans when he announced who he was nominating for head of the Department of Labor. It's House Representative Lori Chavez DeRemer.
Okay.
Lori Chavez DeRemer is a Republican from Oregon, but remember the labels.
Oh, from Oregon.
Right.
Yes, got it.
Outside of Portland.
Yes, right.
Okay, let's just dig that a little deeper.
Yeah, right. Got it. Okay.
So while Lori is a Republican, she is the daughter of a proud Teamsters member, and she and her husband are small business owners, but she has always been pro-labor, pro-employee and pro-labor for her entire tenure in the House of Representatives. She was only one of less than a handful of Republicans, for instance, that signed on to the PRO Act, which would have made union organizing much faster and easier. That pick was, the phrase I use, supported by the Teamsters. I would say suggested by the Teamsters. That's just me reading the tea leaves. So do not assume that because this is a Republican administration, the DOL is going to be anti-union or not want to support labor in all the ways that can rear up. One of the things that has been suggested under her leadership that may change, for instance, this is just one of the things, are H-1B visas. And we do have another episode that talks specifically about immigration. But one of the things she supports is increasing the minimum wage requirement for H-1B visa candidates.
Okay.
Another, which would lower, right, which would make it more difficult, essentially, for employers to bring in immigrants to fill positions. Another thing we can expect, I expect under her leadership, is enforcement of just immigration compliance in the workplace in general. And that would be her cooperation with other agencies as well. But I think we expect to see quite a bit of that. That's important, as we know. Trump campaigned a lot on immigration issues, and unions believe that employers hiring undocumented immigrants drives down wages. Okay. So we can expect to see some of that under her leadership. But the takeaway here is the Department of Labor is going to be led by a very pro-employee, pro-labor
Interesting
leader, which you don't normally expect in Republican becomes
And she
elected.
will have to be confirmed, right?
Yes.
Okay.
And again, crystal ballery here, but based on what I read, she's likely to get through. Some Republicans are upset, so we'll see. We never know, but there's a lot. They have to pick their battles.
But it's a majority,
and this may
I would
not
think.
be one that they're going to fight over.
Got it.
Those are the predictions I've read, so we'll see.
Good. All right, well, let's talk then about the NLRB.
Yep.
And the first thing I want to say is you and I primarily focus our practice on employment matters, right?
Yes.
And so, in full disclosure, I did consult our colleague, Keith Eastland.
Thank God.
Thank God. So I just want to tell
Thank God for Keith, and thank God you consulted. Because I love you, but
That's exactly right.
I want to know what Keith thinks.
I gotta give Keith full credit here, really. I'm talking about the things that what he's what he sees coming, and he's been thinking a lot about all of this. Right. So anyway, thank you, Keith.
And let's be fair, a whole team within Miller Johnson does nothing but think about union.
That's exactly right. You and I are, we can, we know Keith enough to be, enough to know when
enough
to
be
Keith.
Enough to know when to call Keith and his team. Yeah.
Okay, so here's what Keith had to say. He had the exact same comments as you, which is, first of all, don't forget we're living in sort of a new world in which we can't just assume that because a new administration has a Republican president that the NLRB isn't going to be friendly to unions, because this is a different administration, okay? Also, I think it's important just for a minute to remind our listeners how the board works, because it's actually quite interesting.
Interesting to us.
Interesting to us.
And hopefully to some of you.
The NLRB doesn't have commissioners. It has members who issue decisions like a panel of judges do.
Interesting.
Okay. So they hear litigation. The cases come up to the NLRB, and they get to decide those cases. And it's those decisions that then drive kind of the current rules and guidance of the board. Does that make sense?
It does.
The leader of the NLRB is actually the general counsel, the head lawyer. Okay. And the head lawyer then gets to decide what legal positions he or she wants to take and what cases to bring before the board. The board then issues decisions on those cases. Okay. This process, by the way, is why typically labor law can just swing like a pendulum from one administration to the next, right? Because we just have a new panel of judges who see the world differently in a different general counsel, bringing...
it's as if the Supreme Court just changed over every 4 years.
Thank you.
Right?
Yes, exactly. Right. So in this case, the current general counsel is named Jenny Abruzzo. Almost certainly, Trump can fire her immediately. He has the authority to fire the general counsel. He almost certainly will do and appoint a new general counsel. That general counsel will then have the ability to begin to set priority and decide what cases are we looking to take on so that we can change these current decisions. Okay? And the general counsel will do that. But the turnover of the board will require Senate confirmation.
So this is reminding me of the EEOC.
It is a little bit.
Okay.
But here's the really interesting thing. The NLRB currently has 2 open seats.
Really?
It's a 5-person board.
Yeah.
It is currently a 2-1 Democratic majority. So we can do math.
You can do math.
That means that the new administration will have the ability to appoint, right? 5 minus 2 people.
Okay, now I'm with you. Okay, right away.
2 people right away.
We don't have to wait for terms to expire.
We do not have to wait for terms to expire to get a majority.
Okay.
But that will require Senate confirmation. So that will take time, but not as long as the EEOC.
So I think this will be fascinating.
Me too.
Because I am not sure if all the Republicans in the Senate, because the Senate, U.S. Senate is controlled by a Republican majority now, they may not be as friendly to labor as Trump is.
I don't know.
Because...
Who knows?
So we'll see.
Who knows?
Yeah, it will be interesting.
Yeah.
It will be interesting.
It'll be interesting. So the NLRB will have a Republican majority sooner.
Yeah.
But the actual changes can take a while because they have to go through litigation. Yeah. It starts with a hearing before an ALJ, an administrative law judge, and then it gets appealed and blah, blah. So that process does take some time. Okay. So again, I think I wouldn't expect that to happen. It's probably a year before, at least several months before we can have a majority, two people get confirmed, we have a majority, they find a case, they bring it up, it gets appealed to the board, and we get a board decision.
Yep.
Okay, so it'll take a bit. What are the things that we see the NLRB looking to change, right? When I say the GC is going to set priorities, I mean, it's not hard. There was a case called CMEX that had a very strong position on bargaining orders, made it very, very easy for unions to seek bargaining orders, meaning avoid an election altogether. Even though this administration is probably more labor friendly, I think that went just too far, right? Other changes I would see coming is a current decision called Stericycle. That was the decision that told employers that anything you tell employees to do in your handbook or not do is probably protected and concerted activity. So you have to have a huge disclaimer to avoid that, and you have to be very, very careful. I think they will pull that back.
Okay. Excellent.
The third piece is that McLaren case. That's the case that told employers confidentiality provisions and non-disparagement provisions in separation agreements interfere with protecting concerted activity and are unlawful. I see them pulling that back as well. So I think those are the three things that are probably highest on the agenda item. And then there's some other minor things, like there's a decision saying captive audience speeches now are unlawful, etc. So we will see I think we will minimally see some pulling back of those things. So we'll see some new decisions from the board applying a more moderate principle, probably more like employers are used to seeing, had been present before the current administration.
Good. Well, that is good news.
Yeah.
But it may take a while. Back to where we started.
It's not going to be immediate.
It's not a flip of a light switch.
That's exactly right.
Okay.
What
People
everyone
need
needs to understand is it's not the case that on January 21st they no longer need to be thinking about these requirements and complying with them.
So continue to talk with your favorite employment lawyers when reviewing handbooks, when drafting agreements and non-disparagement agreement, all those sorts of things.
That's exactly right.
Figure out what the best strategy is for you.
Yeah, that's exactly right. Okay. And also any employer that's updated their handbook to be in a better position to comply with that Stericycle decision.
Yeah.
You might be overly compliant with the new NLRB, right? But there's nothing wrong with being overly compliant and therefore it's not an emergency to update that.
Correct. Yep. And those are, just to be clear, these are kind of case-by-case discussions to have, because a lot of it depends on the individual employer and what their concerns are.
Yep. There's one more agency to talk about.
Yes, the FTC, the Federal Trade Commission, which frankly a lot of employers didn't pay a whole lot of attention to until the last year or two, when the FTC, in a pretty controversial move, proposed a rule that would ban most non-compete agreements in most situations.
We've talked about it on this podcast.
We're not going to go through all the details of that rule because it's
been struck down.
You're stealing my thunder.
I'm sorry.
Right, but what's going to happen now with the new administration coming in? So let's just talk about this fairly briefly, just to level set, again, to make sure we all know what happened. This was a rule that went through the formal rulemaking process that had the impact of law. That happened in April of 2024. It was challenged very quickly in court.
Right.
Where, Sarah?
Texas.
In Texas, of course, as well as this time numerous
I was going to say.
organizations. There were, but mostly in the Fifth Circuit Court of Appeals. So Texas and Mississippi and other nearby states. Eventually, on August 20th, a federal judge in the Northern District of Texas. I'm tired of saying Texas so much. It's such an obvious answer. Let's start guessing which district in Texas. It's too easy to just say Texas. So Northern District.
It was the Northern District.
The Northern District of Texas this time. That blacked the rule and said that the FTC lacked authority to adopt that rule, and it was arbitrary and capricious. that the federal government appealed right away, as one would expect. Crystal ballery, under the new administration, I would expect the federal government to drop
That appeal.
that appeal. I think that the business community is united in that rule went too far. But a twist, again, we're in a new world here, right? Again, we should not assume extremes, right? So we should not assume because a Republican administration is coming in that things are going to swing to the extreme the other way. December 2024, Trump announced his plan to appoint Andrew Ferguson to chair the FTC.
Got it.
Now that we've had our civics class, Sarah,
Will have to be confirmed by the
I'm
Senate.
not going to repeat all of what you said, but just assume, everyone should assume what you said before about the power of a chair.
Right.
The commission applies to the FTC as well, setting the agenda, etc. So Andrew Ferguson is a Republican, and he will be chairing the FTC. But he has said that while he disagreed with that non-compete rule that was issued in April, he does believe some non-competes are unlawful.
Oh, interesting.
So we don't have the details of how that will be fleshed out. I do not know if there will be another rule, for instance, or another alternative is we may see enforcement actions regarding some types of non-competes.
Rather than
by
having
the
a rule,
FTC.
they can still, I mean, they don't have to have a rule to take a legal position that a non-compete is overbroad and therefore violates the Sherman Act.
An example, right? In the Sherman Act, for those that don't live in that world, it
Took me a minute to think of it, but I did.
You're
but
really
I did.
good. You're really good with that stuff. You're really good with names of things. I'm more the concept person. It's antitrust is basically what it is, right? We can't all get together and decide that Sarah can't ever work for another law firm. Like all the law firms can't get together and decide that, because that is a type of antitrust. That is the type of thing the FTC could bring an action against, right? And so what types of non-competes might the FTC take issue with? Again, crystal ballery, but I would be most concerned with non-competes that affect low-wage workers, particularly hourly workers. I think employers are going to have a harder time, even outside of FTC enforcement. I think they're just going to have a harder time in court enforcing those types of things. Workers that really don't have competitive information, secretive, proprietary information.
Sure.
And now I'm going to throw you a softball. Because when we talk about non-competes, frankly, we're usually less concerned with federal.
I know where you're
right?
going.
Because
you are throwing me a bone. This is one of my
hotbed
favorite topics
for state legislation,
State, yes, exactly.
Hot topic.
Exactly. When that FTC rule got struck down, and I agree with you, appeal is probably going to be dropped. That does not change at all the multitude and myriad of state laws now either banning, limiting in scope, having additional requirements for non-compete agreements. So employers need to be aware of the law in the state in which that person is working, right? Before they ask the employee to sign a non-compete. So.
I'm going to pause right there. You said something very important. I want to make sure everyone catches it. Where the employee is working before you ask them to sign it.
Yeah.
Not when you're going to enforce it. I mean, obviously you need to look at it then too. But in some places, it can be unlawful to even ask an employee to sign it.
So you need
like
to know
in California, for instance.
That's true. If they're in California. Yep.
So you said it absolutely correctly, but I just wanted to make sure people didn't get through that too fast. Okay, in our next episode, we'll talk about non-federal agency
We're going to talk about
issues.
other things that are that are
Federal
coming around
and
the
state,
corner.
not necessarily agency actions, but things that the business community needs to be thinking about in the upcoming year.
Looking forward to it.
Fast. All right.
Thanks, Rebecca.
Thank you, Sarah.